My family was at a baseball game, and our 5-year-old climbed onto a trailer that's always parked by the concession stand. He got on the trailer, and the side entry gate collapsed and broke his leg. So what are their legal options? I mean, this is, you know, the kid climbing on a trailer.
Well, first of all, Lanny, I'm sorry that your 5-year-old is going through this, because a broken leg with a 5-year-old, I can also understand how challenging that would be for the parents as well. And this question brings up a lot of issues, and some of the issues, or one of the big issues that it brings up for me, is what's called the attractive nuisance doctrine, which is a doctrine that we talk about when we talk about slips and falls and trips and falls and premises liability cases. And so we're going to talk about that kind of thing tonight. And fortunately, tonight I have somebody from my own law office, Jason Hamola, one of my law partners, and he has developed somewhat of a specialty in trips and falls and slips and falls. And Jason, would you like to explain a little bit about the attractive nuisance doctrine and how that applies to this case?
Sure, Jimmy. And when you're talking about the attractive nuisance doctrine, what you're looking at is basically foreseeability. It comes down to foreseeability. So the attractive nuisance doctrine states that if there is a nuisance, a lot of times you'll see this with swimming pools, but you can see it with just about anything. If there's a nuisance that you can foreseeably see that a child is going to possibly be drawn to it, then you have a duty to maintain whatever that nuisance is in a reasonably safe condition. In this situation, I think the email said that it was at a baseball game.
And it was a trailer that was parked there all the time.
Okay, and it was
near a concession stand.
Parked there all the time. So what you're looking at here is you're looking to see if kids frequent these baseball games. I'm assuming that they do. And the person that owns the trailer, whether they knew that kids frequent the baseball games, and then you would try to see if it's foreseeable for the owner of the trailer to foresee that children would be on and around the trailer and playing around it.
So there are possibly some legal options that Lanny would have then.
Yes,
that's what basically his question was, is what can he do now?
Yeah, absolutely. The idea is if the property owner, the property owner has a duty to maintain the premises in a reasonably safe condition and to warn of any dangers that the property owner, or hidden dangers that the property owner knows or should know about. In this case, I'm assuming that the trailer had something wrong with it, that it was a dangerous condition. And if the trailer had a dangerous condition and the property owner knew about it, then the property owner had a duty to fix it. Not only did the property owner have a duty to fix it, but also to put a warning sign or some sort of barricade up to prevent children or somebody else from going and endangering themselves.